Good morning. We are on the record in the 53rd Circuit Court for the County of Cheboygan. We are providing public access both in the courtroom and also online. And we're here this morning for a bench trial in the case of People of the State of Michigan versus Amanda Lee Murphy. It's filed 24-6916FH. Counsel, you want to place your appearances on the record, beginning with the people?
Melissa Goodrich, Blount County Prosecutor.
And James Gilbert here on behalf of Amanda Murphy.
Okay, good morning. And Mr. Gilbert, do you want the standard sequestration order entered in this case?
I do.
Okay, so for both sides, I'd ask that witnesses would be sequestered and not discuss their testimony one with another or observe the court proceedings either in person or on the live stream. And also, we do have a bit of a technical issue today where the doors don't entirely seal. So if you want to just make sure your staff knows that the witnesses can't be hanging around the door because there'll be some ambient audio leaking out from the court. All right, and this was scheduled for a bench trial. People consent to a trial without a jury?
Yes.
And Ms. Murphy, you had previously waived your right to a jury trial. Is that still how you wish to proceed, to have me decide the case?
Yes, Your Honor.
Okay. All right, and we've already taken that waiver on the record. I won't redo that today. I just wanted to confirm your choice. Ms. Goodrich, opening statement.
I would waive opening statement, Your Honor, based on it being a bench trial.
All right. Any objection to that, Mr. Gilbert?
No objection.
Any opening from the defense?
I would take the same position with it being a bench trial, Your Honor.
Okay. Your first witness, Ms. Goodrich.
Your Honor, as a housekeeping matter, the defense did not object to People's Exhibit 1, which is the lab results, so that we didn't have to go to lab analyst, which I appreciate.
And that is correct.
Okay, if you want to approach. Okay, so People's Exhibit 1 is a lab report prepared by the Department of State Police analyzing item 3. It says residue analyzed, substance identified, methamphetamine. And the defense has no objection to the admission of People's Exhibit 1.
My client and I discussed the matter and there is no objection.
Okay, 1 is admitted. Okay, Ms. Goodrich.
I'd like to call Jeffrey Becker Moore, please.
Mr. Moore, if you want to come on up. Yeah, right to the stand here, and as you arrive, remain standing, face me, and raise your right hand, please. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Okay, you be seated.
Can you state your name for the record, please?
Jeffrey
Your entire name?
Becker Moore.
Thank you. And where are you employed?
Where I'm Muller Aerospace.
Okay. And you're just coming off the night shift?
Yeah.
Okay. Do you know an Amanda Murphy?
Do I? Yes.
And how do you know her?
We used to date.
Okay. And so how long approximately have you known her?
Maybe a year and a half.
And do you see her here in the courtroom?
Yes.
And can you identify what color shirt she's wearing for the record?
Gray.
And I'd like the record to reflect that he's identified the defendant in the courtroom.
So moved.
Were you with Amanda Murphy on June 14th of 2024?
Yes.
And were you both in a vehicle?
Yes.
Was there anybody else in the vehicle?
Mr. Becker Moore, I'm going to have to ask you to speak up a bit so that we can make sure we're making a good audio record of your testimony.
Prior to being in that vehicle with Amanda Murphy, did you place anything inside her purse?
No.
Were you involved in a traffic stop with law enforcement while you're in the vehicle with Amanda Murphy?
Yes.
Yeah, I'm going to object. And these questions are all leading, Your Honor.
Overruled. I don't think they're directing what the answer is. They're directing him to the topic. I guess before we go any further with this testimony, though, I do see, I'm aware that Mr. Becker Moore had charges that were pending in this court, and I remanded it to the district court. And I see Mr. Nightingale in the courtroom. Is Mr. Nightingale Mr. Becker Moore's attorney?
He is.
Okay. And Mr. Beckermore, you've had a chance to consult with Mr. Nightingale about your testimony here today and any jeopardy that you be placed in?
Yes, Your Honor.
Okay. All right. And was there, well, I guess that's the defense will get into that. Okay, I just wanted to make sure we addressed Mr. Nightingale in the courtroom and that we didn't, you don't need to talk with Mr. Nightingale or anything about this?
We discussed, no.
Okay, okay, I'm sorry.
Thank
Go
you.
ahead.
Your Honor.
And Jeffrey, Mr. Moore, you have a reduced plea deal with the prosecution based on you agreeing to give truthful testimony here today, correct?
Yes,
And you're originally charged with a felony, but that's been reduced to a misdemeanor plea, and the case has been remanded to district court in exchange for your truthful testimony.
that is correct.
And there's also an agreement that anything that you say here in court today would not be used against you in that case. Is that your understanding?
Yes.
Thank you.
That was entirely leading, but I suppose you have no objection to that because you wanted that on the record.
Absolutely.
Okay.
Yeah.
Now, during that traffic stop on June 14th of 2024, did you have any knowledge about what was in Amanda Murphy's purse?
Not at all.
Did you later learn that there was controlled substances in her purse?
Yes.
And were those, who owned those controlled substances? If you know.
I would believe her, but you know what I mean? If they were in her purse, I know they were not mine.
And you had no knowledge of those being in her purse at that time?
No.
And knowing that you were involved in a traffic stop, if you had known that there was something in her purse, what instruction would you have given her?
I mean, I would have probably, you know, back in the day when I was getting high and trying to avoid the law and whatnot, I most likely would have told her to get rid of it or hide it before the cops came to search the car.
And on June 14th of 2024, you gave her no such instruction.
I did not give her any instruction like that.
Thank you. No further questions.
Any cross-exam?
Good morning.
Morning.
Mr. Becker Moore, there was other drugs found in that car that night, that morning, correct?
Yeah, there, you know, the report says yes.
Was there items found in the trunk that was yours?
That's what the report says. The report says there was items found in the trunk.
Okay, you were there at the stop, right?
Yeah, they
Okay.
didn't show me what they found at the stop.
There was a dog there, wasn't there?
There was a dog, but again, they pulled me into the car and I didn't see what they found. There was a lock bag. They asked me what the combination for the lock bag was. I didn't know the combination for the lock bag. I didn't know what they found in the lock bag. I didn't know what was found until I seen the police report.
So did you have meth in the car or not?
There was, yes.
Okay. Was that yours?
It was mine.
Okay. And was that in the trunk?
Yes.
Okay. Because you were in control of the vehicle, right? You were the driver?
Yeah, I didn't know what they, you know what I mean? I didn't know. Then at the stop, they didn't show me what they found. They just told me that what was in there, you know.
Okay, they didn't show you, but they told you they found methamphetamine in the
Right.
trunk,
And I
right?
admitted to that being mine.
Okay. What was prior to, did you pick my client up at her house that evening?
Yes, I did.
Okay. And when you picked my client up, were you in possession of her purse?
No,
You did not have her purse.
no,
A few days prior to that, you didn't leave her at a Dairy Queen or on the side of the road and let her walk home and keep her stopped?
no.
No? A week before
She
you?
ended up getting out of the car. But
Okay.
She took her purse and all of her belongings.
Okay, and when was that?
There were several times that had happened, you
Okay.
know, throughout our dating. So I can't recall exactly as opposed to the time we got stopped when that was. But I do know that every single time that did happen, she took all her stuff. I made sure I didn't have anything of hers.
Okay,
She was one who would willingly get out of the vehicle.
all right.
No,
So in the week prior to this traffic stop, how many times did that happen? That she got out or you had her get out of the car and walk?
I mean, I'd say once, twice,
Okay.
twice most,
And
couple
none of
times.
those times did you keep her purse?
None.
Were you, did you at any time witness a needle that you had used in that the week prior to this incident?
No, I wasn't using needles at this time, so
Okay. And you weren't familiar at a pill bottle that my client kept marijuana in?
marijuana,
Right,
no.
okay. Were you aware of a pill bottle that my client kept anything?
I mean, she's prescribed her medication, Adderall, so
Okay,
she obviously had her Adderall in the prescription bottles that they came in.
okay. Any point in time, did you witness any cellophane that had any drugs in it?
No,
Did you ever have your drugs in cellophane?
you know, I was using it at the time, but no,
Okay. And you never used one of my client's pill bottles to carry anything?
I never used any of her pill bottles.
Okay. No further questions. Thank you.
Thank you.
Any redirect?
No redirect.
You can shut down, Mr.
I'd like to thank and excuse this witness from subpoena.
Yes. You're all set, Mr. Gauthier. You're not intending to recall?
I'm not.
Ms. Goodrich?
I'd like to call Trooper Carlson, please.
Carlson, you want to come out to the witness stand here and as you raise your right hand for me. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Can you state your name for the record, please?
Alex Carlson,
And where are you employed?
Michigan State Police,
And what is your position?
trooper,
What is the total number of years you've served in law enforcement?
6 years.
Thank you. And were you on duty on June 14th of 2024?
Yes, I was.
And who was in the patrol car with you that day?
Trooper Tyler Morris.
Were you involved in a traffic stop with Amanda Murphy in the vehicle?
Yes, I was.
And where was she in the vehicle?
Passenger seat.
Did that traffic stop occur in Cheboygan County?
It did.
And who was the driver of the vehicle?
Jeffrey Becker Moore.
And was your contact during that traffic stop more with Jeffrey Becker Moore or the passenger Amanda Murphy?
Mr. Becker Moore.
Did that traffic stop involve a search of the vehicle?
Yes, it did.
Were there any controlled substances found in the vehicle?
Yes, there was.
And where were they found?
In the trunk area of the vehicle.
Did you confront Jeffrey Becker Moore about the controlled substances in the trunk of the vehicle?
Yes.
And did you tell him what you thought they were?
Yes.
What were they?
I believe them to be methamphetamine.
And what was Jeffrey Becker Moore's response to you asking about the methamphetamine in the trunk of the vehicle?
He was initially in denial of it.
Did he change that at any point in time?
Yes, he did eventually admit to knowing that it was there. It says,
And that was still on scene during the traffic stop?
yes.
And did you have any contact with Amanda Murphy during that traffic stop?
If I did, it was briefly.
And that was primarily Trooper Morris said that contact?
Yes.
Thank you. No further questions.
Thank you.
Cross-exam?
Just briefly. Good morning, Trooper.
Good morning.
So there was about how much methamphetamine was found in the vehicle on your search?
I think each corner baggie was under a gram.
Okay. And that was found in the trunk?
Yes.
Okay. Did you find anything up in the passengers area?
There's a pipe with methamphetamine residue in the center console of the vehicle as well.
Okay. Did you find a needle when you searched through the?
I did not find it.
You did not. Okay. And so your focus was mainly on Mr. Becker Moore.
Correct, yeah.
Thank you very much.
What was the, I'm sorry, any redirect?
No redirect.
Trooper Carlson, what was the reason for the stop?
Defective platelets. burned out.
And can you describe for me how that proceeded then to search the vehicle?
I guess I'll just go over what we had observed prior to.
Sure.
Saw the vehicle initially going eastbound on M68. Vehicle, once we got behind it, I did a U-turn, got behind it, turned off to a business on the south side of the road. I continued on, did another U-turn. The vehicle came back out on the road going westbound. At this time, we were able to get up on it enough to get its plate. The vehicle then turned off into the Burger King parking lot, parked. Due to this abnormal behavior, we believe there's criminal activity to be afoot. We went over to the McDonald's Shell station and just observed the vehicle from over there. And there we can see it parked there for a sustained amount of time. Trevor Morris observed it to have someone got out of the vehicle, open and close the trunk, and we were able to get the plate. Observed to be Jeffrey Becker Moore, prior controlled substance charges. When it came back out, we knew that there was defective plate lights. Got behind it, did a traffic stop, and contacted with the drivers.
Then what happened after the contact?
I asked him for his driver's license, which he did not have on him. And I asked him to step in the vehicle and then spoke with him outside the vehicle towards my patrol vehicle.
Okay. And then what happened next to lead to then the search of the vehicle?
I had asked him if there was anything in the vehicle. He said there was not. Asked him if we could search the vehicle. He was okay with the front and rear. Initially, he was okay with the front and rear compartments of the vehicle being searched, just not the trunk. Which I suspected that area to contain something that he did not want us to know about. It eventually turned into a question was asked if a canine would alert to the vehicle, and he said it would not. And then he altogether decided not to give us consent to search the vehicle.
Okay.
So then we had a canine respond to the scene.
How long did it take for canine response to get up?
I am not sure on the timeline, but it was not very long period amount of time.
Okay, thank you. Ms. Goodrich, any further questions as a result of the court's question?
No, Your Honor.
Mr. Gilbert,
Yeah, thank you.
please step down.
Thanks, sir.
All right, Ms. Goodrich.
I'd like to call Trooper Morse to stand, please.
Trooper Morse, raise your hand for us, sir. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record, please?
Tyler Morse,
And where you're employed?
Michigan State Police.
And what is your position?
I'm currently assigned to Straits Area Narcotics Enforcement,
And how many years total have you served in law enforcement?
approximately 4.5 years.
By being on the Straits Area Narcotics Enforcement Team, have you received any special education or training?
Yes, I have.
And what is that?
I've gone through interdiction training, nonverbal communication training, identifying recreational and legal narcotics, interview training with drug suspects.
And have you also become familiar with street names for certain controlled substances?
Yes,
Were you on duty on June 14th of 2024?
yes, that was.
And were you in the patrol vehicle with Trooper Carlson?
Yes, that is correct.
And were you the main contact with Amanda Murphy?
I was.
And when you approached her, what did you ask?
As I approached her, I asked her just to begin with general travel plans, where they're coming from. She advised they were coming from her house in Wolverine. They were heading up to Jeffrey Becker Moore's residence in Cheboygan. As I continued speaking with her, I asked if there was anything illegal in the vehicle. She looked at me and said, "Not that I'm aware of, not on me," and then quickly glanced over at the center console of the vehicle. Continued to talk with her more about if there being anything illegal in the vehicle, and she was very apprehensive to say that there was not anything illegal in the vehicle. Was very unsure. Told me that if there was anything in the vehicle, that would have been methamphetamine, as Mr. Beckermore was currently addicted to that drug, and she believes it was possible that he could have hidden that drug in the vehicle at that time.
And she specifically stated methamphetamine.
Yeah, we, as I recall, I refer to it as ICE with her, which is a common slang term for methamphetamine.
Thank you. And was there a point in time where you conferred with Trooper Carlson to see if her story about where they were going matched with Jeffrey Beckermore's story?
Yes.
And did they match?
No, they differed slightly.
Did you then have a second interview with Amanda Murphy?
I did.
And what happened during that second interview?
That second interview occurred after I got consent to search her bags. She had a drawstring bag and a purse on her. She gave me consent to search those. And while searching her purse, I located a prescription pill bottle cap that was inside of the cellophane bag. And inside of that prescription bottle cap, there was methamphetamine residue. So after I located that, I spoke with Miss Murphy again, and she admitted to me that was indeed methamphetamine in that cap, but she said that it belonged to Beckermore, and that she found it 2 days prior, along with a needle, and she placed them in her purse 2 days prior to that.
Did she admit to putting the needle anywhere else besides her purse?
She did not that I recall.
And you were wearing a body cam during these admissions of the methamphetamine being in her purse and being there for 2 days?
Yes.
Thank you. No further questions.
Cross exam.
Good morning.
See, watching videos so much, I feel we know each other. So you were the primary officer that investigating my client?
That is correct.
Okay, so the two of you separated, Mr. Beckermore and my client, and each of you handled one of them?
Correct.
Okay. Initially, my client was pretty adamant that no methamphetamine was hers,
That is correct. Yes.
and pretty adamant that she does not use methamphetamine.
Yes, I believe I recall. Yeah, we talked about her use, and I'm certain you were correct. Yeah, she said she did not use methamphetamine.
And that was true throughout the course of both interviews, was that not?
I believe so.
And at no point in time did she acknowledge that any of the methamphetamine was hers.
That is correct.
And I believe, at least during your second course of the interview, you were giving her quite a few options to tell you the truth and asked her if she'd work for you and that type of thing. Is that correct?
That is correct. Yes.
Okay. And she still didn't admit that any of the methamphetamine was hers
That is correct.
and continued to deny her use.
That is correct. I believe so. Yeah.
Going back to the initial things that you found a pill bottle. Can you give us a little bit more?
Yes, it was just unlike a prescription pill bottle that you have the white cap that you push and twist off. I just located that cap. That cap was inside of a cellophane bag.
Okay.
I believe there's just a miscellaneous piece of paper in there as well. But inside of that pill bottle cap was upside down, and inside of it was the methamphetamine residue that I located.
Okay. And that was in my client's purse.
Correct.
And so I'm asking this question for, I guess, personal knowledge also. Is that common to put methamphetamine in a pill cap? Why would, with your training with narcotics and that type thing, what's the use of a pill cap, and is that a proper way to store it? I mean,
I thought it was kind of an odd way to store it, but people I've seen it stored in numerous containers, all different shapes and sizes. I could speculate as to why it was in a pill cap, but I can't say with certainty other than that's just where she had it at that time.
and it was just the pill cap. It's not the rest of the bottle, just the
Correct.
white cap.
Correct. Just the cap.
Now, is it a cellophane bag or wrapped in cellophane?
It was just placed inside of a plastic cellophane bag.
And again, it was it was just residue. There wasn't any substantial amount there.
That is correct.
What triggered you to think that that was ice or methamphetamine when you saw that cap?
From prior experience, I've seen methamphetamine dozens of times
Okay.
and the residue, so
So the residue, so you recognize it being residue.
correct.
And then there was a needle involved here there was a needle that was found. Can you give a little bit of explanation about where it was found and what the story was with the needle?
Yeah, that is correct. I do not recall who located the needle for certain, but I know I'm speculating, but from my memory, I think it was either one of the deputies that assisted, but it was located underneath the passenger passenger chair of where Miss Murphy was sitting. Just
Okay, so you're not the one that actually found it.
That is correct. I did
Okay.
not. I did not locate that.
So you don't know if it was in a phone case or anything like that?
Correct. I do not know.
Okay. And do you remember what the story was with the needle that was found?
She told me that she found the needle in that pill cap 2 days prior and put it in her purse, and that they belonged to Becker Moore. That's the only backstory I have on the needle.
Okay, but the needle wasn't found in the purse, it was found on the floor.
Correct.
Okay. And my client consented to you searching her stuff?
That is correct.
Okay. And so there was no hesitation on her allowing you to go through her purse and check her things?
Correct.
I have no further questions. Thank you.
May we direct?
Yes. Was it the cap or the needle that you sent to the lab for testing?
I did not personally send it, but I believe it was the cap. The Trooper Carlson sent that.
Thank you.
Any further questions on that point?
No, thank you.
Trooper Morris, can you describe for me a little more detail about how that consent search happened? Like, what was she outside of the vehicle?
Yes, so Trooper Carlson had Mr. Beckermore out of the vehicle, was talking with him in front of his patrol vehicle. At that point, I had Miss Murphy step out of the vehicle. I believe we were waiting at this point in time for the K-9 to arrive. I had her step from the vehicle. She came out with both of her bags. I then asked her if I could search her bags, and she said yes, I could. And then I searched them. I placed her bags on the hood of her vehicle and searched them right within view of her.
And do you know how long it took for the K-9 to get there?
I couldn't give you an exact time, but if I were to give you an approximation, I would say 25 minutes.
The consent search that was given occurred on the front end of that or the back end of that?
For Miss Murphy's
Yes.
purse, it would have been after we had requested the K-9, if I recall. So it would have been towards the back end while we were still waiting for the K-9 to arrive.
Any further questions as a result of the first question?
No, yeah.
Mr. Gilbert?
No, Your Honor, thank you.
Okay, thank you.
Thank you.
All right, Ms. Goodrich?
The people rest, Your Honor.
Mr. Gilbert, any witnesses?
Yes, first witness I'll call is Christina Duvall.
Okay. Ms. Duval, if you want to come on up to this witness stand, please. As you arrive, please remain standing and raise your right hand for me. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, John.
Okay, you can be seated.
Hi,
Hello, ma'am. Ma'am, can you state your name for the record, please?
Christina Lee Duval.
And Christina, Ms. Duvall, what is your relationship to my client?
I'm Amanda Murphy's mother.
Okay, and I'm just gonna ask you some general questions about her purse and those type of things. On June 14th, did you have contact with your daughter or my client?
I did.
All right, and can you tell the court what happened and what items she had with her that day at And first off, where did you have contact with her? Was that your
It was
residence?
at our residence.
Okay.
Yes,
And then can you tell the court what you remember about?
yeah, she woke me up, it was later, I was sleeping, and she said Jeff showed up.
I'd object, Your Honor, it's hearsay nature of the questions.
She told me,
Hang on. Response, Mr. Coe.
I don't think she, okay, yes, Your Honor. That would be hearsay.
okay, Amanda
Hold on,
walked
hold
up.
Hang on.
Okay,
You cannot state, Rick, remember we talked about this, you cannot state what Amanda told you, just you can tell me what you observed.
what I observed was Amanda leave the house with Jeff without her purse.
Okay. And do you remember if she had her purse prior to that?
She did not,
Okay. How do you know that she did not have her purse prior to that?
because I took her to go try to find him to get her purse.
Okay. And when did you take her to go find the purse?
Or the day before, or the day before that, when she came back without her purse, and it was in his car, we tried to find him.
Okay. So a couple days prior to the 14th, you had been looking for Mr. Moore.
Yes,
What other items were you aware that Mr. Moore had of Miss Murphy's?
he had a backpack that I believe was at the trailer that we had to go back to get some clothes and stuff that he had at his place of residence that we wanted to retrieve as well. To get all her belongings from him because she was cutting ties with him.
Okay, so to your knowledge, they were in the midst of sort of a breakup.
Oh, yeah, definitely.
Okay. But yet he picked her up that night and they took off.
Yes,
Yeah, yes, they did. Okay. But prior to that, you had, where did you go to try to find her items, her backpack and specifically her
we went
purse?
to his work. We went to his place of where his dad lives. We went to the place where he lives. And we couldn't find him nowhere.
Okay. In that whole time period, she did not have her purse.
She did not.
Okay. Did the same incident happen within a week that he kept her stuff?
Yes, there were multiple times that this happened.
Okay. And each of those, what did you do? What was your role when those items were with him?
To try to talk to Jeff and I personally have talked to Jeff and was like, "Dude, just give her stuff back. I mean, come on, just go your separate ways, so. I have had conversations with Jeff because Jeff is, well, I don't need to go on all that, but Jeff needs help. And Amanda is not the person to help him. He
Okay.
needed to go get help.
Okay.
My daughter's not the one to help him. She can't bring that stuff around her children. And she became aware of it. It was a different person if you saw.
I'd object,
that.
Your Honor, as to speculation as to Ms. Murphy's
So-
thoughts or experiences.
That's my
Hang
feelings.
on. When there's an objection, you just have to pause and let it sort it out.
Okay,
That's fine.
So in particular, that in the evening of the 14th, Amanda did not have her purse when she left
No, she
left
did
your
not.
house.
she did not.
And to the best of your knowledge, Mr. Moore had it prior to the days prior to that.
Yes,
Okay. And that's not the first time it had happened.
correct.
I have no further questions. Thank you.
Can you cross-examine?
Good morning.
Thank you.
Sounds like not a big fan of Jeffrey Becker Moore.
It's not that I don't like Jeff. I like Jeff as a person, but my daughter's not a qualified enough person to help somebody who has his issues.
And you and your daughter are close?
Yes. I'm close with all my children.
Okay. And on June 14th of 2024, what times were you with Amanda Murphy?
She was at home with me pretty much all day.
And since we're talking about almost a year ago now, how much certainty do you have on what times you're with her?
I was with her all day until she woke me up and said that Jeff is here.
Okay, and because it was a year ago, how much certainty do you have on when you're with her?
I'm 100% certainty I was with her.
Okay, and when you say together all day, from what time to what time?
From the time that we woke up in the morning until the time that she left out the door with Jeff.
And what time did she leave out the door?
And it was about midnight, somewhere around there. It was late at night. It was late at night. She woke me up. She woke me up and told me she was leaving with them. And then I got the police from the cops, which I think might have been close to 3 in the morning.
And prior to June 14th, what time to what time were you with Amanda Murphy?
Prior to June 14th,
Yes.
I was with Amanda every day except for the day that she walked home from, except for 2 days before when she walked home from Indian River.
Okay, so on June 13th,
But she was at home with me.
all day,
Yes,
24 hours.
yes.
How about June 12th?
She was not with me all day.
What times was she with you?
She really wasn't with me that day. She was with Jeff that day. Until after she showed up at home, walking home from Indian River, which it's still daylight out, so, but I can't be the exact time of that.
Okay. And were you with Amanda Murphy when, on June 14th of 2024, were you with Amanda Murphy when she had got her purse?
She walked out the door without a purse, and I picked her up with the police. She had her purse.
Okay, so you were not with her when she got her purse?
I was not.
Okay. So you did not observe her obtaining her purse?
I did not.
Okay. Thank you. No further questions.
Can you redirect?
Just for clarification. So my client left your house on the 14th, about midnight,
Yep, that is approximately, it was late.
and then you said you had a call from the police. Can you tell me what the essence of that call was?
They asked me to come pick my daughter up.
Okay, and that was after the stop?
Yes.
Thank you. No
And
further.
then we got another call from the police, asked us to come back, pick Jeff's car up. I'm like, what? You know, but
Okay, so you had a couple calls that night from the police?
yes,
One to pick Amanda up and one to come get the car?
yes.
No further questions. Thank you.
Can you refresh on those points?
No, you're not.
Okay, you can step down, Mr. Paul.
Right. Absolutely.
Can she be excused from her subpoena?
Yeah, she's.
Okay,
excused
so
from my
you can
subpoena.
remain in the court if you want, or you can leave. It's up to you. Mr. Gilbert,
I would call Amanda Murphy.
Mr. Murphy, if you want to come up. Raise your right hand for me. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, can you see?
Amanda, can you state your name for the record, please?
Amanda Lee Murphy.
And Amanda, you know why you're here today.
Yes, I do.
Okay. And you heard the officers talk about when you and Mr. Moore were stopped on June 14th.
Yes, I did.
Okay. And that there was items found, at least one item found in your purse.
Yes,
Okay. At the time of, at that time, and remember you're under oath, at the time of that stop, were you aware that there was a pill cap, a pill bottle cap with cellophane in your purse?
yes, I was.
Okay. Were you, and what did you think, where did you find that pill bottle cap?
I found it in Jeffrey Becker Moore's car 2 days prior to that with the needle. And I was going to confront him and I put it in my purse and I had forgot that I had put it in my purse. I thought that I may have been under the seat with the needle that I found. So, I didn't remember it being in there, but, it was in there.
Okay. Were you aware what was in that? Did you know that there was methamphetamine in that cap?
I did not know for sure, but I assumed yes.
And so tell me, when was it that you took that item?
It was 2 days before in Indian River at McDonald's. I had found the items and I was going to confront him, but when I came out of McDonald's, he was gone.
Okay. And so did you have your purse at that point in time?
No, I did not.
Where was your purse at?
In his car still.
Okay. And that's where, so you put the items in the purse before you went into McDonald's?
No, they were underneath the seat. And I might have put them in my purse. But I found them underneath the seat.
Okay. And that was before going into McDonald's?
Yes.
Okay. So what happened at McDonald's that Mr. Moore left you there?
We were fighting, and he was acting crazy and out of control and irate, and I wanted him to take me home, and he did not want to take me home. So, you know, I went into McDonald's to use the bathroom, and when I had came back out, he was gone.
Okay. And what items did you have with you when you came out of McDonald's?
My phone.
Okay. And so you didn't take your purse into McDonald's with you?
No, I did not.
And you didn't take your backpack or anything like that?
No, I did not.
Okay. When was the next time that you saw your purse?
It was when he picked me up, when he showed up at the house that night. I got into the vehicle to initially get my purse and my belongings.
Okay, what came to be that you were riding with him in Indian River?
He showed up at the house, and I got in the vehicle because I wanted to get my belongings from him, not only his car, but his house as well. So that's why I agreed to go.
Okay. All right. And so from the 14th and from the McDonald's incident to the 14th, when he showed up at your house, you were not in possession of your purse. Do
No, I was not.
you have any idea where your purse was at?
I knew it was in his car.
Did that incident take place where he had your purse in the week before?
Yes, he locked me out of his house here in Cheboygan near Riggsfield Road. And I had to call the cops because he locked me out of the house with all of my belongings in it.
Okay, did you get your belongings back that day?
Yes, I did.
Okay. So the time period that you did not have your purse was the couple days before the 14th.
Yes.
I have no further questions. Thank you.
Any cross-examination?
Thank you. So Ms. Murphy, 2 days prior to June 14th of 2024, you grabbed what you believed to be methamphetamine and placed it in your purse.
Yes.
And then 2 days later, you were with Jeffrey Becker Moore and you grabbed your purse and it still had that methamphetamine in it.
Yes.
And then you told the officer that, yes, you do think it's ice, and yes, it's been in your purse for the last 2 days.
Yes.
Thank you. No further questions.
Any requests or any regret? Okay, thank you. You can step down. Mr. Gilbert,
I have no further questions.
any rebuttal proofs?
No rebuttal, please.
Closing argument, Ms. Goodrich.
Your Honor, the Michigan Criminal Jury Instruction 12.5 guides us for unlawful possession of a controlled substance. First, that the defendant was possessed. Amanda Murphy herself testified that she grabbed what she believed was methamphetamine, placed it in her purse, and still had it in her purse 2 days later, and told the officers that she believed it was methamphetamine and had it in there for 2 days. Regardless of what she was going to use the methamphetamine for, whether it was personal use or to give to someone else or to confront Jeffrey Becker Moore, doesn't matter pursuant to the elements of the crime. It was the fact that she knowingly possessed methamphetamine. Second, the next element is that she knowingly possessed a controlled substance. We know that from her testimony today, to her statements to Trooper Morse on June 14th of 2024, and from it being tested positive for meth. And so I believe that the elements of possession of methamphetamine have been met. Thank you.
Thank you, Mr. Gilbert.
Your Honor, I think this has an interesting twist to it, but basically due to the constructive possession of the purse. Initially, my client's testifying that she assumed, but wasn't positive that there was methamphetamine there. So you'd have to knowingly and intentionally possess methamphetamine to be guilty of the charge. I don't believe the prosecution's met that standard based off of those facts. But then the interesting thing is when Mr. Moore leaves her at McDonald's and takes her purse, he now deprives her of that possession. And though she's sitting next to the purse when she gets back into the car, at no point in time does she leave the car with the purse and take possession back. It might have been with her. She was on her way to get the rest of her stuff from his house by riding in the car. I believe there's a gap there due to that, him denying her access to that purse, which eliminates the possession. And so my argument is that by him leaving her 2 days earlier with whatever would possibly be in the purse, terminates the possession. And then it doesn't reattach to my client until she would actually take the purse or go someplace with it. Truly, it's in the car where it's been for the last 2 days. by her merely getting into the front seat, I don't think establishes or reconnects that possession. Thank you.
Thank you. Your rebuttal argument.
Your Honor, she testified that the reason why she went with Jeffrey Beckermore was to regain possession of that purse in her backpack. She had both things with her when the officer asked her to step out of the car. He then later asked her to search those items that she had with her. So I don't believe that she stopped possession. There's also joint possession, but we don't have any testimony that Jeffrey Beckermore accessed her purse during that 2 days. So I still think it's the sole possession. But even if it was joint possession, that still would be valid.
All right, thank you. Well, the defendant is charged in a 1-count felony information with the charge of possession of methamphetamine. The burden of proof is beyond a reasonable doubt. The elements are simple. First, that the defendant possessed methamphetamine. Second, the defendant knew that she possessed a controlled substance. The first element is clearly satisfied in that within her purse was a pill bottle cap that did have some residue of substance on it that was sent to the State Police Crime Lab, and Exhibit 1 indicates that it was chemically tested, and it was in fact methamphetamine. She was in possession of that. It's in her purse, her private bag, and she did. Trooper Morse testified that she stepped out of the car with those bags, and he asked her to for consent to search them, and that's when he found it. So she was in possession of it. The second element is, did she know that she possessed a controlled substance? And this is where the defense has presented a different theory about that, that this was Mr. Becker-Moore's drugs, and that Miss Murphy was just had just sort of grabbed them to confront him about that, and she says she forgot that they were in her purse, that it was in her purse partly because she didn't have her purse for a couple days, and that she was not knowingly possessing that other than just in a passing fashion to confront him about it. The prosecutor seems to argue that legally that doesn't really matter, and I think that's probably correct, that she didn't have any lawful authority to possess that. However, I mean, if that was really what had happened, there might be some grounds to question that element. Like if a parent, for example, were to find cocaine in a child's bedroom and grab the cocaine to confront the child, I don't think anybody would think that the parent should reasonably be charged with possession of the cocaine. But in this case, Miss Murphy's statement has some problems to it. I mean, we have Mr. Becker-Moore's testimony, which the court takes with many grains of salt. His body language indicated some defensiveness of what he was testifying about today. He was a little bit squirrely about some of his testimony. First trying to make it seem like he didn't know the combination of some bag, and sort of heading down a road of disclaiming knowing what was in the trunk, and then when pressed, admitting that he knows what was in the trunk. And also he was charged with felony crimes and received a misdemeanor outcome in exchange for his testimony here today. So I think a lot of what he has to say is tough for this court to rely on. But also we've got Ms. Duval, the defendant. On the other hand, we have the defendant's mother testifying to support the defendant's testimony here today, that she didn't have the purse for a couple of days, that Mr. Becker-Moore had the purse when he left in the car without her. And in fact, the mom says, we were driving all over the county looking for Mr. Becker-Moore to get the purse back. There's some credibility issues with that as well. I mean, clearly Ms. Duval has a motivation to try to help her daughter out today. And some of that story is inconsistent with what Miss Murphy told the officers at the scene. She says, I put it in the purse 2 days before. She claimed that it did belong to Mr. Beckermore, but she didn't say anything about he had the purse. It wasn't, I didn't even have the purse. She's not saying that to the officer at the scene. So this story that's presented today is inconsistent with what was said at the scene. And also, when I was carefully listening to Miss Murphy's testimony and her mother's, the week before, Mr. Beckermore allegedly had kept belongings of hers, and she and Miss Murphy obtained the assistance of law enforcement to retrieve possession of those items. So if he had deprived her of her purse, one would think all she'd have to do is reach out to law enforcement for help to get the purse back. But she says she didn't do that, which doesn't make a lot of sense because she had just done that the prior week. What seems to make more sense to my mind is, gee, that past episode a week before, somewhere along the line lodged in her mind as an excuse that she could try to give in this case. So there's some things about that just don't add up right. It's tough to know what to make of that because on the one hand, Mr. Beckermore's testimony is not super reliable, but neither is the defendant's or Ms. Duvall's. The only clear-cut testimony we have is from the two law enforcement officers who make a valid traffic stop, and during that stop obtain a consent search of Miss Murphy's purse. It's her purse. She's holding it in the car. She's holding it when she exits the car, and inside that purse is methamphetamine. I think that's really the clear facts, and that's really all the facts that are needed to establish her guilt, unless she didn't even know it was in there. She's not even saying that today. So her story, I'm not sure whether it would amount to a defense, but she, I don't believe it nonetheless. But even if I were to believe it, she knew that was in her purse. So therefore, I think the prosecutor has proven both elements by proof beyond a reasonable doubt. And I would therefore find Miss Murphy guilty of the charge of possession of methamphetamine. So Miss Murphy, what we'll have to do is schedule this for a sentencing hearing. I'm going to order you to cooperate with a pre-sentence investigation so that we'll have you talk to the probation department. They'll ask you some more questions about just your life circumstances so I can decide what an appropriate sentence is. And let me see if I can grab a date for that. I think I've got a little bit of a staffing issue with probation right now, so I think I'll put that out about 6 weeks, out to August 12th at 2:30 in the afternoon. (2:30 p.m.) Ms. Goodrich, anything as to bond?
Your Honor, this would be her first felony conviction, so I would not object to bond continuing to sentence.
Okay. Ms. Murphy, I'm not going to cancel your bond. You'll remain on bond. You have to comply with all of those conditions. I want to remind you, we have had a couple issues, I think, with bond conditions earlier in the case. I want to remind you now that we've had a trial and I have found you guilty beyond a reasonable doubt, bond, you're not entitled to a bond. It's entirely within the court's discretion. So if there were any violations of bond conditions, I could cancel that at any time without really much reason at all. So I want you to strictly comply with those things. One of the things I'm going to be looking at is whether, to what extent you may have any issue with substance use or abuse, and whether there's something we can do to help you get on top of that if necessary. So you want to comply with those bond conditions for testing and be honest with the probation officer. I don't really know you. I don't know your situation, but if that's going on in your life, you don't want to try to hide it, because if you hide it and then we find it during probation, this doesn't go well with you. If that is something you need some help with, then be honest about that during that process, and we'll do what we can to help you get on top of it, okay? But otherwise, we'll see you August 12th at 2:30. Anything further from you people?
No, Your Honor, thank you.
From the
Yeah,
audience?
thank you.
Okay.
Thank you, Your Honor.
Yeah, recess.
Delon, Cassie, Rosemary, Delon, 24T7085113FY.
Good morning, Judge. Message from back, Mr. Lawson.
All right, Ms. Delon, your name?
Good morning, Judge. Can you hear us?
I can, Detective. Your name?
Detective Sergeant Mark Driscoll, Trent Police.
Ma'am, your name?
Cassie Delon.
You don't have one with her, do you, Lieutenant Mercure?
He's got two sides.
Okay. Well, counsel, what is she going to do? She was supposed to be here a year ago, April of 24. I revoked her release, forfeited the bond due to failure to appear and test weekly, as I ordered. Told her she had to appear immediately for arraignment. She didn't.
I did explain all that to her, Judge. She's going to be pleading guilty with an explanation.
Well, I don't really even need to deal with that. I'm going to arraign her on the charge here, which is a one-count complaint for possession of cocaine.
Wasn't she already arraigned, Judge, back on
She was arraigned,
April 24th?
but I'm going to do it again since it's been a year.
Okay.
So does she stand mute?
We'll stand mute and waive your incorrect.
Ma'am, I'm going to explain your rights to you again. You're charged with a 4-year felony possession of cocaine. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference, Lisa, I just want to make sure, give me another bond sheet, please. You've got this set for 9:30 in the morning on July 1?
Yeah, you're not here that day, so Judge Hessen will have to handle it.
And then July 8th at 1 p.m. That
Yeah.
will be in front of me. Okay, ma'am, do you understand that?
Yes, I do.
Do you still live on Marion Drive?
Yes,
Same unit?
yes.
All right, counsel, what would you like to say regarding bond?
Judge, taking into consideration Ms. DeLon's past history, we would still ask for a personal bond. Ms. DeLon's failure to appear, honestly, Judge, was caused by an abusive relationship, an abusive ex-boyfriend that she was living with. He was both physically and emotionally abusive to Ms. DeLon. He would beat her almost on a daily basis. He would lock her in the house. Every time she got a phone, he would break it. That's why on the hour away, there's a note that there were several calls made. There was one line was busy, the other one had a full mailbox because she wasn't able to communicate with anyone. He prevented her from working, Judge. So it was, and she just got out of that relationship, so she's trying to put her life back together. Ms. DeLon also suffered as a result from PTSD and other mental health issues. She understands she has a problem, Judge. She is willing to go to treatment. She understands that she's got to make some affirmative steps here. to help herself before the court would be willing to show her any type of discretion. We asked the court for a personal bond in this matter, Judge. She hasn't been able to work because of everything that's been going on. So her finances are limited. And looking at her criminal record, Judge, aside from two other issues relating to possession or drugs, she does not have a significant criminal record. Yes, the court may see her as a flight risk, but she assures me that moving forward, she's going to make 100% effort to be here and resolve this issue. Isn't that correct, ma'am?
Yes.
Detective, anything?
Your Honor, we'll leave it to your discretion. I'm sure you're aware, just so the record is noted, that she does have a warrant out of Wayne County. It's no bond warrant. So just so you're aware.
Ma'am, you live right down the street. I usually hear I can't get a ride. And I just don't go for this. I'm sorry that you were going through that. I hope you were making police reports. If everything that Mr. Gates just told me is true, your ex-boyfriend or whatever, the abusive relationship that you had to undergo, he should have about 10 or 20 criminal complaints for domestic violence filed against him. 35,000, 10%. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer. No alcohol, no marijuana, no illegal drugs. AANA 3 times a week, and you do have to test weekly. And I do have to know that you violated the bonds repeatedly. I revoked the release, forfeited the bond pending a hearing. You asked them to call and set you up for arraignment. You just didn't show up on any of these things. Your first court date here. And again, if you post that bond, you come into the court that day, and have probation set you up for weekly testing. If you don't post, we'll see you July 1, and that will be at 9:30 in the morning. Good luck. Thank you very much. Have a good day.
Thank you, Judge. Have a good day.
Close out a petition and give her another court AA sheet, will you please? Philip Russell.
Yes, Your Honor. I'll get it to her.
Thank you. Philip Russell Conklin.
Would you consider bond if she
No,
puts on a tether?
no. Thank you. Sometimes we get stuck with cases that we can't win, right?
Thank you.
Philip Russell Conklin, 25R713371. Your name, Lieutenant?
Detective Lieutenant Steve Murphy, Rockwood Police.
Raise your right hand. You solemnly swear affirm under the penalties of perjury the testimony given these proceedings will be the whole truth, self you got.
I do, Your Honor.
All right, go ahead.
Your Honor, on 5/11/25 at approximately 2:45 in the afternoon, Officer Stephen Corn with the Rockwood Police Department was dispatched at 21722 Huron River Drive within the city of Rockwood for a felony assault complaint that had just occurred. Upon Officer Corn's arrival, he spoke to the victim, Johanna Lopez. Ms. Lopez stated that she was having a conversation with Philip C.'s girlfriend, CJ, regarding Mother's Day dinner. During the discussion, an argument ensued, and as the argument escalated, CJ became aggressive towards her. At one point, he threatened to kill her. CJ then pushed Ms. Lopez up against the wall, pinned her with one hand, and with the other hand, he retrieved a knife out of his pocket and held it to her throat. At that point, she was threatened that she was going to get cut or harmed. As the argument continued, she grabbed her cell phone and called 911. At that point, Philip left the residence and took off on foot from the scene on location. Officer Corn then spoke to Philip's mother. Her name is Lisa Summers, and she identified her son as Philip Russell Conklin, white male, 9'3" of 87. And Officer Corn was able to confirm the identity of him through the Michigan Secretary of State. When it comes to convictions, Your Honor, all the 3 convictions he has are on December 19th of 2007, and they're all out of the Lane County Circuit Court in the state of Oregon. One count of the offense of theft, first-degree larceny. Second one is burglary, first degree. And the third one is a felon in possession of a firearm. I submitted a warrant to the Wayne County Prosecutor's Office. You have a charging document in front of you.
Based on your sworn testimony, I find the crime felonious assault was committed. There's probable cause to believe the crime was committed by the defendant. Also that he has 3 prior convictions, as you testified to, giving rise to the habitual offense. People against Cody Snyder. Are we okay?
We're okay. Shane had to move some.
That's okay. 25R706513. Lieutenant, your name?
Detective Lieutenant Steve Murphy, Rockwood Police.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, on December 29th, 2024, at approximately 3 o'clock in the morning, Officer Freddie Harshbarger and Officer Christopher LaFleur, both of the Rockwood Police Department, were dispatched to 20306 Hero Drive, Apartment 11, in the city of Rockwood, regarding a possible home invasion domestic. Upon arrival, officer spoke to Lauren Weinstein, who stated that she had some people over to her house that evening in question, and that her ex-boyfriend, Cody Snyder, was calling her. Should be noted that they had been broken up for approximately 3 months, and he currently does not live at the residence. Lauren stated that Cody kept calling her, so she shut her phone off. After shutting her phone off a little while later, Cody showed up at her apartment and started kicking the glass sliding door. At that point, Lauren had her friend, Kevin Shepard, go upstairs to avoid any confrontation. As Cody kept kicking the door, he then retrieved a hidden key that was outside the apartment where Cody knew it was at because he used to live with her. Unlocked the door, entered the apartment, went over to the utensil drawer in the kitchen, grabbed out a unsure item at that point, and then started to run upstairs to look for Kevin. As he was running up the stairs, Lauren tried to block him from going up there. He grabbed her by the hair and threw her to the ground. As they were fighting, Kevin noticed that he had what appeared to be a hunting knife in his hand. So he ran out down the stairs and outside the apartment with Cody chasing him with the sharp object in his hand. He was able to get away, and the police were called. I sent a warrant to the Wayne County Prosecutor's Office.
It says scissors. Was it scissors or?
Well, she said it was scissors. He said it was a knife. Lauren said it was scissors. So I'm not sure if he grabbed 2 things out of the drawer, but he described it as a hunting knife. And then Laura described it, it looks like scissors. But the officer did recover a set of scissors.
I'm going to just add on the complaint and or knife. Okay?
Yes, Your Honor.
I'm going to add that on both the complaint and the warrant and count 1 after the word scissors and or knife. Jeez. All right. Give me 1 second. And I'll note that you signed the complaint, court assigning and dating the complaint and the warrant for the arrest of the defendant for domestic, felonious assault, and illegal entry without permission. You're all set. Thank you very much. We'll get these into lien. Thank you. Golden Management versus Audrey Wynn. Did you adjourn that? I'm sorry. Williamsburg versus Trevor Kimes and Victoria Smith, 2502357. Do I have Trevor Kimes or Victoria Smith? Ma'am, your name?
Victoria Smith.
Sir, your name?
Trevor Kimes.
All right, and Mr. Smith.
Good morning, Your Honor. Andrew Smith, P64541, appearing on behalf of the plaintiff Williamsburg Square. This is a non-payment or rent possession only matter. This is our first hearing.
Mr. Kimes and Ms. Smith. Let's start with you, Mr. Kimes. Did you listen to and understand the rights?
Yes, sir.
Ma'am, did you?
Yes, sir.
Do either one of you wish to speak to a lawyer? Mr. Kimes, rather?
No, sir.
Ma'am,
No, sir.
either one of you intend to apply for funding?
No, sir.
No, sir.
All right. Mr. Smith, tell me how much is owed.
Your Honor, at this time, the total, in rent, the total amount owing is $1,065. There is $170 late fee. The bailiff fee, filing fee, court fee total $83.43 and 63. The total amount of those costs is $1,356.43.
Do you agree that you owe that amount, Mr. Kimes?
Yes, sir.
Ms. Smith,
Yes, sir.
can you pay that, Mr. Kimes or Mrs. Smith?
I can have it Monday.
Mr. Smith?
That'd be great, Your Honor. I would ask the court to enter writ, which wouldn't be till July 3rd. The hope is they can come and pay and we can dismiss this matter.
So I want you to understand that he's essentially asking me for a judgment.
Yes.
So if I grant that, that means you'd have until July the 3rd to pay up or vacate. If you don't do either one of those, you'd be evicted. You understand that, Mr. Kimes?
Yes, sir.
How about you, Ms. Smith?
Yes, sir.
All right, so counsel, the total amount owed is $1356.43. Does Mr. Smith have your permission to sign your name to a proposed consent judgment that sets forth those terms and that you owe $1356.43 and have to pay up or vacate by the 3rd of July? Mr. Kimes?
Yes, sir.
Ms. Smith?
Yes, sir.
All right, so he's going to sign your name. We're going to get the judgment out to you, hopefully today or tomorrow at the latest. And you just have to know that you have to pay up or vacate by the 3rd. Also, you have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal. Do you understand that, Ms. Smith?
Yes, sir.
Mr. Kimes?
Yes, sir.
Any questions at all for me?
No,
Either
sir.
one of you? All right, good enough. That's what we'll do. You're all set. I wish you both well. Good luck to you. Thank you.
Thank you, sir.
Thank you.
Have a nice day.
You too. Williamsburg versus Sierra Thomas, 2502358.
Your Honor, I've not had Miss Thomas check in.
You can take a default on this. Go ahead.
Your Honor, the plaintiff is asking for a default judgment. The total amount due and owing is $2,692.53. That's broken down. Rent totaling $2,375.99. 2 late fees of $70 totaling $140. Bailiff fee, court filing fee is $70.04 and $31.50, totaling $2,692.53.
Defendants failed to appear. Default judgments entered in favor of plaintiff against defendants. The writ date in this case will be on July the 3rd. Williamsburg versus Santia Prather, 2502359. Ms. Prather, start your video. State your name.
Santia Prather.
Good morning, ma'am. Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No, thanks.
Do you intend to apply for funding?
No.
Counsel, give me the total balance that's owed.
Total balance is $1,521.54.
Do you agree that you owe that amount, ma'am?
Yeah.
Can you pay that?
Is that for May or is that for this?
It includes June rent, right, counsel?
Yes, Your Honor, it's 2 months, May and June.
Right.
May is already paid. I already paid May.
Ms. Burns, good morning. Your name?
Good morning. My name's Jessica Burns.
Did she pay May?
Let me bring up her account here just one moment.
Prather, when did you make that payment?
Like a couple weeks ago, maybe like 2
Yeah, it looks like on June 10th.
She made the May payment?
Yes.
So how much, how much do you think that she owes?
Currently, I show $1,461.54.
Oh. Well, boy, you guys are off. What's the monthly rental rate?
Yeah, Your Honor.
$1,275.
All right, so they agree that you paid May rent, but they think you owe 1,275 for June rent, plus the other figures here would amount to
Court costs, filing fee.
court costs and statutory attorney fee for a total of 1,464.54. Do you agree that you owe that amount?
Yes.
All right. So
Sorry
what do
about
you? So let's give me the breakdown on this, please. I've got 1245 in past due rent. Any late fees?
One late fee of $70.
Okay, and then how much in filing and service and
$70.
you can just add them all up.
Okay, sorry, $101.54.
All right. Do you agree that you owe all that, ma'am?
Yes.
When can you pay that?
I don't get another check until the July 8th, but it's really not, it wouldn't actually be enough to cover the whole cost. So I could pay on it, like I could put what I'm gonna have on it.
What do you guys want to do?
Your Honor, at this point, I'd ask to enter a judgment, and if Ms. Prather wants to work on a payment plan, we're more than happy to work with her, but we need that judgment for assurance.
Ma'am, I'm going to give them a judgment after hearing for 1464.54.
Okay.
I'm going to say that if you pay, and you can add this, if you pay $850 by June the 3rd, that the writ date will be extended until July the 11th.
Wait, did you say pay by June 3rd or did you mean July 3rd?
July 3rd. If you pay $850 by July 3rd, if I misspoke, my apologies, writ date will be extended until July 11th. So that if you pay $850, you would only owe $614.54, and that'll extend the writ date all the way until the 11th, but you have to pay the balance on that by the 11th. Do you understand that?
Yes, I understand.
Okay, do you have any questions?
Nope, I'll be paying it.
All right, I wish you well. And does Mr. Smith have your permission to sign your name to this judgment? I'm going to do this one after hearing. So does he have your permission to sign your name to that proposed judgment?
Yes.
Actually, yeah, let's just do it after hearing. You don't need to sign her name.
Okay, thank you.
She'll submit it. He'll submit it. I'll sign it. And you just make sure you write those dates down. Okay, ma'am?
Okay, thank you.
I wish you well. Anything else, Mr. Smith?
That's all I got. I saw, off the record, John Kennedy Sr., I think, is your cousin, if I don't mistake correctly.
Yes.
Saw him Saturday night, him and Jim Kennedy and a bunch of their family, and he told me to tell you hello if I run into you. So.
Yeah, give them my best. I only see him seemingly at funerals. It's terrible.
I know,
Good
right?
people.
Right. All right.
Give them my best. Thank you.
Will. Good
Thanks.
seeing you. Take care, Your Honor.
All right, Kathy Josephine Wilder Kiss, 25B722945. Have we called Brownstown?
Yes, sir.
All right.
Ready, Your Honor.
Good morning.
Good morning.
Your appearance?
Thank you very much, Your Honor. Attorney Thomas, Court P77177. Here on behalf of the defendant, do you say your name for the record, please?
Kathy Wilder.
All right, what are we going to do on this? Does she stand mute, waive formal reading?
Yes, Your Honor.
All right. I'll enter a not guilty plea. Ma'am, I'm going to advise you of your rights. Detective Morrison, your name?
Detective Sergeant Morrison, Brownstown Police Department.
Ma'am, you have the right to remain silent. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that? You got to keep your voice up.
I do.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by your lawyer at that questioning. Do you understand that?
Yes, I do.
You have the right to a probable cause conference within 14 days, the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, the people will have to show that the crime was committed and that you were the one who probably committed the crime. This is custodial interference, kidnapping, a 1 year and 1 day felony. Do you understand everything I've said?
Sir, what is 1 year?
Okay, I'll talk to you about that in a second. I will. Let me tell you this. Pre-CC will be July 1 at 9:30. Preliminary exam will be July 8th at 11:30. Anything basically punishable by, for the most part, there's a couple of crimes, but anything punishable by more than a year is a felony. They've charged this by as a 1 year and 1 day, making it a felony as opposed to a misdemeanor, which it would be if it was a 1 year. So they've got the extra day. Do you understand that?
Yes.
Okay. So probable cause conference July 1 at 9:30, preliminary exam July 8 at 11:30. Those will be in front of Judge Hessen. So I need you to remind me on this one a little, Sergeant. I know I only did this a month ago, but tell me real briefly what happened.
Yes, Your Honor. So there was a custody between both parents. There were some allegations. CPS was involved going both ways. And basically, Miss Yes refused to turn her son over to the father. He made some complaints. And so we sent that in to the father did end up getting his son back, though. And there haven't been any complaints since, to the best of my knowledge. So I believe that Miss Wilder Kiss was, from what I was told, she was in some sort of custody downtown. I believe that she was charged or arrested and put in jail for something down there for contempt, but I don't know this particulars behind that.
Yes, Your Honor. Basically, the child reported being sexually abused by the father. A doctor signed an affidavit saying that he believed it was true. Ms. Kiss at that point allegedly refused to return the child. The judge downtown said, return the child or go to jail. Ms. Kiss did do a number of days in jail. This was months and months ago. She's been released by the judge from contempt. The child is now only having supervised visits. I believe 10 visits have already occurred, roughly, Your Honor, with no incident.
Supervised how?
At a location appointed by the court.
Where?
You know,
On 4th Street in Wyandotte, downriver, counselor, downriver.
So you just meet the child there?
Yes, I do.
Is the child otherwise in the custody of Mr. Joseph Wilder?
Yes. Still share joint custody.
But he doesn't have supervised visitation, just you.
Just me.
Well, I just want you to know we're not going to get along very well if you violate orders. Do you understand what I'm saying to you?
Yes, sir.
What are you asking for, counsel?
thank you, Your Honor. I would ask for a personal bond in consideration that my client has no violent criminal history. When she was 20, roughly, in Florida, she got in trouble for indecent exposure. But besides that, Your Honor, no criminal history. She also, as for being a danger to the public, only risk could be alleged to be her child, but the circuit family court has put something in place. And those visits, we've had a review after those visits, and they've recontinued with no incident, Your Honor. So I'd ask that the court consider a personal bond.
What are you asking for there, Detective?
Your Honor, nothing. I'll just leave it at the court's discretion. Like I said, since this thing kind of kicked off months ago, it seems like things have been pretty quiet. And if the court has put measures in place that are being followed, I have nothing to add.
$15,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any circuit court order with respect to visitation. So if the order is supervised visitation, that means it's to remain as such. If you took that child and left the state, we are going to have a big problem. You cannot have any contact with prosecution witnesses except through your lawyer. Again, you cannot violate a law. You must appear in court as directed. I'm not going to order a GPS tether because if I do, you're going to be sitting in the county for 6 days or 5 days until they can fix it. But I'm telling you, I hope you take me very seriously. Do not remove that child. Do we understand one another? I can't hear you.
Yes, sir.
You also have to go over to the Brownstown Police Department to be fingerprinted and photographed by 1 PM today, okay? We're gonna give you an order, we're gonna give you your bond condition, we're gonna give you your notice, and that's it. Anything else, counsel?
No, Your Honor.
All right, thank you, detective. Have a good day. Good luck, ma'am. You're gonna be in front of Judge Hessen when you return on those dates. Thank you. People against Christopher John Henthorn, 25W713365. Detective, your name?
Detective Kyle Davis.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
On 3/26/24 at approximately 14:26 hours, officers Nicholas Mitchell and Edward Cash with the Woodhaven Police Department performed a traffic stop at northbound I-75 and Vreeland Road inside the city of Woodhaven, Michigan limit. On the defendant, Christopher John Henthorn, officers observed Henthorn was on his cell phone and driving in his hand. Ultimately, Henthorn was arrested on probable cause for being in possession of narcotics that was found inside his vehicle during the traffic stop. The United States Border Patrol Canine Unit and handler Agent Sean O'Donnell performed a free air sniff of the vehicle. The canine displayed a positive indication of suspected drugs inside of the vehicle. Officers then searched in the vehicle and found multiple baggies of suspected drugs along with drug paraphernalia. These items were confiscated for evidentiary value and later submitted to the Michigan State Police Laboratory for analysis. Defendant Henthorn was released pending the lab results. The Michigan State Police Laboratory later report revealed 2 of the evidences that were collected as suspected drugs tested positive for narcotics. One of the items tested positive for cocaine in the amount of 5.18 grams, and the other tested positive for methamphetamine in the amount of 23.83 grams. A digital scale with white powder residue was confiscated as evidence from inside the defendant's vehicle, along with $592 in cash in his wallet. That was also collected as evidence for probable cause for possession with intent to distribute.
You have this prior conviction of August 28 of 07 for home invasion second.
Are you asking me, do I have that in front of me at the moment?
You have that. You have his criminal history. Does that show a conviction on that date? Again, it's August 28 of 07, home invasion second, because they're charging habitual second here.
Yes, that is correct.
Now,
I've got a CCH.
Go ahead. Go ahead.
August 22nd of 08. Pretty lengthy here.
I'm looking for the home invasion second on August 28, 07, unless that's an incorrect date.
I'm not seeing it on my copy of the of his CCH. I should probably run it again. This was ran.
You have a home invasion second conviction somewhere on there. Yeah, I'm looking at it. It's got August 28, 07, home invasion second. The rest of these, for the most part, appear to be, I don't know what, there's no disposition on a UDAA, but I'm going to authorize, except I want to ask you a question. You said this occurred March 26th of 24. The complaint alleges March 26th of 25. Which was it?
If I said 24, I stand corrected, 25.
Okay, good enough. Based on your sworn testimony, I found the crimes: possession with intent to deliver less than 50 grams of cocaine, possession with intent to deliver methamphetamine were committed. Those are 20 year. And then you have a second offense notice giving rise to the habitual second. I'm going to authorize on both the complaint and the warrant on those charges. You are all set. Thank you very much. Have a good day. We'll put that in lien. People against Mitchell. Nicholas James Mitchell, 25B 714401. Your name, detective?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God?
I do, Your Honor.
Okay, you can proceed.
Your Honor, on June 21st of 2025, at approximately at 5:55 hours, Officer Kenneth Paul was sitting in the turnaround and conducting traffic enforcement on I-75 south of Pennsylvania Road in Brownstown Township. At that time, Officer Paul observed a 1995 Buick Roadmaster Michigan plate 5QSB70, which, as Secretary of State and Lane indicated, was EIV no, indicating no insurance. Officer Paul entered southbound 75 and caught up with the suspect vehicle in the area of southbound I-75 and Dix Toledo Road in Brownstown Township. As Officer Paul closed in, the suspect vehicle increased speed and began to drive away from Officer Paul. Officer Paul activated his patrol vehicle lights and attempted to catch back up to the suspect vehicle, but it continued on at a high rate of speed. Officer Paul caught back up with the suspect vehicle again in the area of southbound I-75 and West Road with emergency lights and sirens activated. The vehicle continued southbound at approximately 120 miles per hour in a 70 mile per hour zone, and Officer Paul notified dispatch that he was in pursuit. The suspect vehicle continued to flee from Officer Paul at 120 miles an hour, 70 mile an hour zone, and continued to change lanes, going from the far left lane to the far right lane as it was overtaking vehicles. The suspect vehicle continued to flee at approximately 110 miles an hour in a 70 mile an hour zone as it passed Greenland Road. As the suspect vehicle approached the Gibraltar Road exit ramps, the suspect vehicle positioned itself in the right lane of travel. It braked abruptly, drove through the gorge between southbound I-75 and exit 29B, and exited the freeway at exit 29B for westbound Gibraltar Road. Officer Paul continued to pursue the suspect vehicle as it turned onto westbound Gibraltar Road. The suspect vehicle continued on westbound Gibraltar Road at approximately 70 miles per hour in a posted 45 mile an hour zone, swerving from the curb lane into the center turn lane to pass traffic. The suspect vehicle then went northbound on Hall Road from Gibraltar Road, and Officer Paul terminated the pursuit due to traffic conditions at that time. Officer Paul and Officer Nicholas Walker were both familiar with the suspect vehicle due to prior contacts in the Preston Point apartment complex in Brownstown, Michigan. After terminating the pursuit, Officer Paul and Officer Walker set up near the apartment complex to see if the suspect vehicle would arrive. That day at approximately 6:09 p.m., very shortly after the first pursuit ended, the suspect vehicle entered the Preston Point complex, and Officer Walker attempted to stop the suspect vehicle due to its reckless driving within the complex. The Preston Point apartments are a posted 12 mile an hour zone, and it is privately owned with private roadways. After the suspect vehicle nearly struck Officer Walker's patrol vehicle, it fled out of the complex and onto southbound Fort Street. At that time, Officer Paul took over as the lead car, and another pursuit began with lights and sirens activated. The suspect vehicle began to smoke and was driving at approximately 45 miles per hour in a posted 55 mile an hour zone. The suspect vehicle then slowed down to a near stop, and the driver of the suspect vehicle jumped out of the vehicle and fled on foot across the southbound and northbound lanes of Fort Street. Officer Walker and Officer Paul pursued on foot, and Walker deployed his canine vein to assist in apprehending the driver. The driver surrendered to officers in the parking lot of 28291 Fort Street and was taken into custody without incident. Officers positively identified the driver as Nicholas James Mitchell, both verbally and using his Michigan Secretary of State photograph. At the time of these pursuits, Officer Paul and Officer Walker were both operating black Chevrolet Tahoes with reflective lettering. The word police is the largest wording on these vehicles and is on the driver and passenger sides, as well as the rear liftgate. The vehicles were equipped with blue emergency lighting visible from 360 degrees and an audible siren, all of which were activated during both pursuits. The officers were also dressed in full police Class B uniform with police patches and badges visible to the driver and other motorists. On June 22nd of 2025, Mr. Mitchell was interviewed by Brownstown Detective Attard and admitted that he had fled from police on June 21st of 2025 while traveling southbound on I-75 towards Gibraltar Road, and again when the police attempted to stop him in the Preston Point apartment complex. Mr. Mitchell stated that he fled because he panicked. A lien Secretary of State check for
Because he
Nicholas
what?
panicked.
Okay.
A lien Secretary of State check for Nicholas James Mitchell showed that his driver's license was suspended at the time of this offense and that he has 3 prior convictions for operating while suspended, revoked, denied, including a conviction for operating while suspended, revoked, denied out of the 33rd District Court on December 11th of 2024.
Based on your sworn testimony, I find the crime of fleeing elude third was committed and drive while suspended. Second was committed, probable cause to believe those crimes were committed by the defendant. You can bring them in for arraignment. Mr. Gauthier, your appearance. Clearly comes out of the lockup there. Mr. Mitchell, your name?
Nicholas James Mitchell.
All right.
Good morning, Judge. On behalf of Mr. Mitchell.
All right. How does he wish to proceed for purposes of arraignment?
We'll stand you in waiver.
I'm going to advise you of your rights, Mr. Mitchell. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. At that time, your lawyer will discuss the case and see if they can resolve it with the prosecutor. If it does not resolve at that stage, you have the right to a preliminary exam within 7 days thereafter. If the preliminary exam, at least as to the felony count of fleeing elude in the 3rd degree, they have to show that that crime was committed and that you were the one who probably committed that crime. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court on that charge and all other charges contained in the complaint and warrant. Do you understand that?
Yes.
Probable cause conference, July 1 at 9:15. You'll be in front of Judge Hessen. July 8th at 11:15 will be your preliminary exam. So 9:15 in the morning, 11:15 in the morning. Again, that's July 1 and July the 8th. All right. Now, what would you like to say regarding bond?
Judge, Mr. Mitchell is asking to request a personal bond on his behalf. He is federally employed judge. He does have.
Where does he work?
He's working at Wendy's in Brownstown. He
Can I
makes
see
roughly
him
about
up here?
$500 every 2 weeks after tax.
He was just in front of me, wasn't he?
I believe so, Judge, yes. He also guaranteed me that he'd be here for court, Judge. He's not, he wants the court to know that he's not a flag risk. Record, Judge. I don't believe he's also a danger other than just one particular incident. We asked the court to consider a personal bond or the alternative.
You know that you have a warrant out for your arrest on a drunk driving out of Wyandotte, the 27th? It looks like it was a probation violation. Are you aware of that?
No.
Now you are, okay? What are you asking for there, Detective Tulas?
Your Honor, as you pointed out, this is the 2nd time he's been before you on a driving while license suspended offense in 2 weeks. At this point, we think it would be appropriate to assign a low cash bond on this. During this incident, he did endanger the lives of numerous people and almost struck a patrol vehicle before fleeing from officers on foot. He's shown a blatant disregard for the law in the court. Like I previously said, we'd ask for a low cash bond.
Those two things show me he's a flight risk. What else? Did you want to say something, Mr. Mitchell? It sounded like you were trying to talk.
Yeah, but I was going to say,
don't talk about the case. Don't talk about the case. You got the right to remain silent. You should not talk about the case.
Oh, no, I wasn't about to talk about the case. I don't have anything in here for me to.
Judge, I believe what he's trying to say is that he doesn't have access to his funds and he doesn't have a way to get in touch with anyone that can bail him out. He'd request that he be allowed to either access his phone so he can post his own bond, be able to make a phone call so that he can contact someone.
You guys will give him you don't have, where's your phone at now?
It's in the car. It's in the impound lot.
I see.
I can't do anything. I can't, like, I would cash myself out, but I can't send money to nobody. And then I could call my mom, but she's at work. And then the person that I know could come bail me out. I don't know none of their numbers by heart. That's what I'm trying to say. If you can get me out on a personal bond, I swear to God on everything I love.
I got somebody with a warrant out for their arrest, and I got somebody that I just heard testimony from a detective that they were driving 120 miles an hour and they weren't riding on Mars. 15,000. Hey, listen, don't interrupt me. 15,000, 10%. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. I wish you well. July 1, you'll be in front of Judge Hess and you can renew your bond reduction at that time. Good luck to you. And you are going to let him make a couple calls there, Detective, right?
Yes, Your Honor.
Thank you very much. Have a good day, Mr. Mitchell.
I'm confused.
So on the record in the matter of the state of Michigan was Brandon O'Connell, 25866. And Detective, your name for the record, please.
Detective Sergeant Devin Geiger, reading on information I believe for Detective Haskin.
Thank you. Please raise your hand. Is that we swear or from the testimony you must give this and be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. May proceed on the warrant.
On 6/21/2025, approximately 2:21 in the morning, Wyandotte officers Barry and Harris were patrolling the area of Elm Street, 3rd Street, in a fully marked patrol vehicle, fully marked uniforms. They observed a dark blue Chevy Silverado parked with its lights on and doors open. Officers made contact with the occupants of the vehicle, identified as Austin Cross, Jeremy Denny, and Brandon O'Connell. There was vomit outside the vehicle, and the occupants had a heavy odor of toxins. Cross, Denny, and O'Connell admitted to consuming alcohol and were waiting for a ride home. The occupants were advised not to drive home, and Officer Berry assisted Cross with ordering an Uber ride. Officers cleared the scene without further incident. Short time later, at approximately 2:41 a.m., Officer Berry and Officer Harris observed the same dark blue Chevy Silverado southbound on 2nd Street near Oak Street, later determined to be driven by O'Connell. O'Connell turned eastbound on Oak and accelerated to a high rate of speed. O'Connell quickly turned northbound on 1st Street. Officers activated their emergency lights and sirens on the fully marked patrol vehicles. O'Connell disregarded all traffic control, traveling approximately 60 miles per hour in a 25 mile per hour zone, the residential area. The vehicle then turned eastbound on Cedar Street, and O'Connell exited the vehicle and continued to flee on foot. O'Connell was advised to stop by officers, but he continued to flee on foot northbound on Biddle Avenue. O'Connell continued westbound on Spruce Street, northbound behind the medical building located at 2070 Biddle Avenue. Officer Salzman arrived on scene and issued his and deployed his department taser, which successfully stopped O'Connell, who was arrested. A search warrant was completed for his blood, and that results are still pending.
All right. If the use of the plaintiff, I do find that the offense charge committed, defendant and his probable cause the defendant committed those offenses. All right, counsel, their appearance, please.
Yes, thank you. Good morning, Your Honor. Neil DeBlois here on behalf of Brandon O'Connell, who appears, I assume, from the jail. Mr. O'Connell, can you hear us? State your name, sir.
Yes, sir. Brandon O'Connell.
All right, and good morning, sir. And so today is the date scheduled for the arraignment. Counsel and ask for the arraignment.
My client waives the formal reading, stands mute to the charges.
The court will waive the formal reading. Sir, you do have to write down an attorney. If you cannot afford one, you can have one appointed to represent you. And you did have an opportunity to speak to an attorney today. Is that correct?
Yes, sir.
The court has also signed the petition order for appointed attorney for felony matters. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir? The court's going to enter plea of not guilty, and we have scheduled this matter for probable cause conference on July 3rd at 10:15 a.m. Counsel asked to bond.
As to bond, Mr. O'Connell advises that he is gainfully employed in the field of plumbing with a company called Blue Eyes Trade in Troy. I believe that's right. He indicates he's not on probation or parole anywhere. He is actually, I think we have an update. The address in the file is not the same as the address he's given me. I can put that on a slip for the court. He has an address on. I did not prepare a slip.
Oh.
But I don't know what the court has. He's on Winthrop in Detroit, has been for about a year and a half.
Okay, that is not what we have, but we have the Monroe's training course.
So again, he's been at that address for a year and a half. He, as I say, he's gainfully employed. He's not, he has to his knowledge, there are no warrants, he has nothing pending in any other court. He does in his spare time, he is a caregiver for his elderly grandma. As a court to consider those things and set a reasonable or personal bond in this matter.
All right, Mr. O'Connell. Did you miss coming here or something, sir? You were just here back in October. You just had an issue back in October.
I know you're right.
Right.
I was dumb and I messed up.
Yeah. What are you going on? From October about 24.
Open alcohol got reduced and disruptive behavior. And then loitering, he had given.
All right. So you were given the benefit of the doubt by the prosecuting attorney, and that was on October 24th.
Yeah.
Right. And apparently, sir, you did not take that opportunity very seriously. And the prosecutor offered you that, sir, even with your prior criminal history. You don't have to keep getting in trouble to come into court, sir. You can just come on in and check it out if that's what you want to do. But where is it you work?
Blue Eyes Trade. I work with my uncle, Your Honor.
Okay. And so how often do you work a week?
3-4 days a week, Your Honor. Part-time.
Why are you only working part-time?
We just don't get that many jobs. He's a private contractor, Your Honor.
Okay. So what do you do to supplement your part-time income?
Sorry, Your Honor.
What do you do to supplement your part-time income, sir?
I'm sorry. I didn't hear you. I'm sorry. I'm going a little bit in here.
What do you do to supplement your part-time income?
I mean, there's other things that I do to make money on the side, I mean, it's not just, just because I don't work full-time doing plumbing, I have other ways to make money.
What are those ways, sir?
Cutting grass, just, extra side money.
All right. So if you're in a test right now, sir, what's in your system?
Alcohol, Your Honor.
Alcohol seems to be a common denominator every time you're in trouble, sir.
I know. That's the main reason why I'm always getting in trouble, Your Honor, is alcohol.
All right, Detective Esteban.
No alcohol, no drugs unless prescribed. Also, just due to the seriousness of this, it's another car chase in Wyandotte, another fleeing elude. It just never ends. Serious threat to the public and to the officers and to himself. I'm requesting just for his appearance in court, 10,000, 10%.
All right, the court will know that 2 years ago, sir, you had another matter of obstruction of police that was amended to a lesser offense of disorderly conduct. And you've also had prior alcohol-related offenses, and yet here you are, repeat offenses on both. Given the allegations, given the criminal history this court's taken into consideration, and given the seriousness of this matter, the threat to the public and to Mr. O'Connell himself, the court is going to order a $10,000, 10% bond with the following bond conditions. You're not to possess or consume any alcohol or drugs unless prescribed. You are not to drive a motor vehicle. Even if you have that license or you're not driving a motor vehicle right now, that's a privilege in this state. You don't, the board's not allowing you to have that privilege right now. And also, you're not to be released from alcohol tether through the Wayne County Jail. Any questions?
No, Your Honor.
Okay, we'll see you back on July 3rd. Thank you. Have a good day.
Thank you.
Thank you. Let's go off the record.
Mr. Martin, wait a second. Okay.
Yeah, okay. Well, I wanted to start talking now, maybe so I can have enough time to talk pursuant to my First Amendment right.
Hold on. Okay, now we're on Eric Martin. This is 251756, the People versus Eric Martin.
Good morning, Your Honor. James Gazicki on behalf of Mr. Martin. Your Honor, he's waiving his right to a trial by jury, requesting trial by this court. And also, can I address bond, Your Honor?
Yeah, I signed the order granting discovery. Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend that.
Do you understand that, sir?
I comprehend it. I just want to add, as I told him, I really don't consent to no jurisdiction of this court, but since I'm being forced to make the choice, I'm saying an Article 3 judge is going to be the choice, the forced choice. Article 3 judge.
Okay.
Even though the case shouldn't go, let me mention this too now. The case shouldn't even go that far. We shouldn't even be wasting taxpayers' money, nor my time in here. First of all, I proved my sister lying before on me with the same type of charge, Nessick, okay? I don't know the case number right now. I asked Jasinski to find out what it is. But in the same court, 23rd District Court, the judge is seeing she lied when I questioned her. Did you swing at me before I kicked you? She answered no to that. And it was seen on the camera. She lied. This is especially why I should not be made to wait on this.
Mr. Martin, you have a constitutional right to a trial by jury. Are you voluntarily waiving the right to a trial by jury?
Since I'm being forced to make
well, you're not being forced to make any choices.
Well,
you can have a trial by
jury. So I am being forced.
Mr. Martin, listen, we can get through this, or we can go back and forth, and then I end up muting you, and then that's how we go forward. So let's see if we can do this without that, okay? You have a constitutional right to a trial by jury on this case. Are you waiving your right to a jury trial?
Yes.
And you understand that I'm the judge of the court, that I will be the trier of fact on your case?
Well, I want a motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, Mr. Martin, are you electing for me to try the case, yes or no?
In that forced sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. I'm asking you, do you want a trial by a judge or a jury? And I'm being very patient.
By a judge, I already said Article 3 judge. Article 3 judge.
Okay, well, I will be your judge. I've made that clear. This is a case I have jurisdiction over. It's a misdemeanor that's alleged to have occurred in the city of Taylor. So, so you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me. And you understand, you've had a chance to talk to your lawyer about this, Mr. Martin?
Yep.
Okay.
I also want to make it clear, I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Amy, can you find
Despite
me
the fraudulent presumption otherwise.
possible? All right, give us a second, Mr. Martin. I'm trying to get your jury trial date. We can even do on a state date.
I want to make clear, I'll point out, it's supposed to be 28 days and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific, under the court rules, it should be 28 days without excluding Saturdays and Sundays or the legal holidays. That's made clear, I want to say, under the rule that dictates speedy trial, MCR 6.004C, and also MCR 1.103, the applicability rules that clearly says, where a rule is specific, it applies to that. So that the specific rules control over general rules.
Okay, Madam Prosecutor, how many witnesses?
I would say maximum 3.
Okay, Mr. Gazicki, how many witnesses?
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I'm not, I can't follow, nor can I ask the court to follow it. Just so that's on the record. As far as witnesses goes right now, Your Honor, we would say 1.
Okay.
Can we approach?
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too, while we get time, in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
All right, we're going to set a bench trial July 14th in person at the 23rd District Court, July 14th at 10 a.m.
Your Honor, can we address bond?
You can address bond.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond in this matter.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. So he clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody because he will not comply with my bond conditions. There's no such thing as an unconditional bond. So, okay, bond denied. And Mr. Martin, if you want to file motions that Mr. Gazicki legally could not file in good faith, feel free to file them. He's governed by court rules. He cannot file frivolous motions. So if you want to file more motions, feel free, get it, go at it. But Mr. Gazicki has indicated for the record, he will only be filing appropriate motions with this court. We'll see everyone back on the jury trial. That's my first date.
I have motions to make right now. I have some motions before we leave. I have some motions. Okay, and that is okay. Well, first, objection to what you just said, your statement about, there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under due process. The due process right, be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, and I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before, and there is no evidence at all. We have no case. There's no evidence, and that is not probable cause, as the U.S. Supreme Court said in Beck versus Ohio.
Well, misdemeanor, so we're not having a preliminary exam. We're having a bench trial, and the prosecutor will have to prove the allegations beyond a reasonable doubt. And at that time, Mr. Martin, if at trial date, I assure you this. If she can, you picked a bench trial. I was a practicing attorney for years. I promise you this. If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
You haven't let me finish the first. You let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or it was Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against, we simply have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be, come on, let me finish.
Okay, denied.
The case should be dismissed now.
We'll see you back on your trial date. Have a good day. Okay. Thank you, Mr. Gazicki. That's it, right?